just want to thank you all for I just want to thank you all for coming here and attending such seminars. Your presence does encourage us to conduct and organize much more of such seminars, which are a little non-conventional than the regular things that we chartered accountants usually deal with in our day-to-day life. And such new avenues are something that we should explore in the upcoming days, so that various different revenues of practice and avenues of practice can be explored into. And these new fields are very niche, and in my humblest of the opinion, uh, at this date does not have a lot of competition in it also. So if we start exploring such factors, maybe over the year we could develop an expertise over this and develop a new avenue for our practice. With this, I thank you all again for joining us, and I thank the speaker, madam, for removing her time on a given Saturday. Thank you so much. Thank you so much, Harsh.
Yeah. So I now invite the Ratnagiri branch chairman, CA Prasad Asrekar, to give a welcome address. Prasad. Yes, Prasad. Prasad, you're not, I think the speaker is, you're still on mute, I think.
Hello?
Yes, we can hear you, sir.
Yes. So I welcome all the participants in the today's second day of our lecture on intellectual property rights. Last or yesterday, we have interactive lecture with Rajesh Gadipur sir on the various practical as well as legal aspects for the intellectual property rights. And today we are on the second day of our session. Last or the yesterday's session was also very fruitful, enlightening all of us on the various concepts of the intellectual property rights. And at the same time, today also we are having our intellectual property right lecture. So in the today's very expanding and ever increasing business world, it is very popular concept that is intellectual property rights. So copyrights, patent, trademarks is the part and parcel of our everyday business activities, and therefore as a professional or as a member, we should know the practicalities as well as the legal aspects for the purpose of intellectual property rights, what the legal formalities are, and what is the actual practical concepts and practical problems which we face while having the practice in the field of intellectual property rights. So the Thane branch of WRC of ICI, together with the Ratnagiri branch, it is very wonderful seminar and very thought-provoking which will have the enlightening of all students as well as the members in the concept of intellectual property rights. Okay, so not wasting much time, I have further transfer the activity of the seminar conducting to the Thane branch, CA Harshvardhan Patil sir, and it is my pleasure to welcome all of the participants for the today's second day of such seminar. Thank you, sir.
Thank you, Prasad sir. I request Vice Chairman of Ratnagiri branch, CA Mukund Marathe sir, to give a formal introduction of the speaker. Mukund sir.
Good morning to all.
Good morning.
It is really my honor to introduce such a eminent speaker, Advocate Rujuta Phadke, Rujuta is experienced intellectual property counsel with a background of technology and law. Before going independent, she headed the intellectual property practice of leading technology law firm. She has several years of experience in an associate at an India's top 10 IP law firms. Rujuta is a lawyer and patent agent registered with the Government of India. She is also a visiting professor in intellectual property law. She has worked in a lot of institutions. Rujuta Phadke Intellectual Property. She is a founder of that institution. She was a visiting professor at Ferguson College. She was head of intellectual property right. Intellectual property. She was a head of intellectual property rights and senior legal advisor at Lega Logic Consulting. She was a founder at Patent Designs and Copyright Practice. She was an independent professional intellectual property consultant. She has delivered various lectures on intellectual property rights and patents. She has worked with R.K. Dhawan and Company. I think with this brief introduction, I will hand over the matters to Thane branch chairman. Okay, let me finish this. She was a research associate with Institute of Chemical Technology. She was a trainee at National AIDS Research Institute, Pune. She was a trainee in Serum Institute of India Limited. I think, yes, I have concluded. Please take over the charge, Thane branch chairman, sir. Sir?
Yes, thank you, Mukunji. On behalf of the chairman, I would do the session. Without any other more time, I request our Rujuta ma'am to kindly take the stage.
Thank you so much. I would like to thank ICAI, Thane and Ratnagiri branch for inviting me for today's talk. It is a big pleasure to talk in front of such qualified audience. Good morning to all. So my name is Advocate Rujuta Phadke. I am an intellectual property attorney and the founder of a full service intellectual property law firm having offices in Pune and Mumbai. I'm also a visiting professor in intellectual property law at Ferguson College, Pune. My educational background is in pharmaceutical technology as well as law. I would like to share the link of my firm's website in the chat window for everyone's quick perusal. Just give me a minute. Okay. So my firm predominantly assists individuals, MSMEs, corporations, Indian as well as international, in their intellectual property filings, prosecution, and litigation. Although I have been informed that there was a lecture on IP background yesterday, I would like to walk you all through the basics of IP myself. Just take some amount of today's time period allotted for me to discuss some points here, because these points I think would be relevant in understanding the cases that we would be discussing at length today. The cases that we'll be looking at today have been specifically selected with the audience in mind. We have tried to highlight the cases which you as practicing CAs would find helpful while giving certain basic guidance to your clients, because in our opinion, clients have a huge comfort with their CAs. So, before approaching a third party, maybe a lawyer, first they usually like to have candid conversations with their CAs. So as the first point of contact, I feel these cases would help you have some better clarity in terms of what to talk to the client, what to suggest to the client, etc. Being a lawyer, I can't help but give a huge disclaimer at the start of the talk that we have used certain trademarks and copyrighted material and various IPs of people, different people that have been involved in the case, various case laws. So my firm, we are not trying to pass ourselves off as them. These materials have been used only for educational and instructional purposes. Now, I would also like to propose to the organizers that we have the Q&A session at the end of the talk, because I would be presenting and sharing the screen. So just to avoid switching between the presenter mode and the live stream. So I hope that's all right.
Yes, of course. We will have the Q&A at the end.
Perfect. So then let us start with the presentation. I would be sharing my screen. Just give me a minute. Yes. Is this good for everyone? I guess so. Moving
Yes.
on. Yeah. Okay. So what is intellectual property in a sense? Intellectual property can be defined by a simple sentence, which is intellectual property is any creation of your mind, of any person's mind, whatever tangible or non-tangible manifestations of the creations of your mind can be classified as intellectual property. Now, how to legally protect your creative work or your intellectual property? There are 4 very predominant ways in which you can do that. One is patents, second, copyrights, third, trademarks, fourth, industrial designs. So I'm sure most of you are aware of all these types, but in today's lecture, I'm going to try and explain the differences of each, because each in itself, each type of IP protection itself complements the other in protecting the work, whatever creative work has been created by someone in some way. So it is a misconception that, someone, if whoever has come up with something new, that you can protect it only by one way, or if you do just this one thing, then you will be protected. That's not the case. Typically, in majority of the cases, this has to be a group of protections that you seek in order to best protect someone's innovation or some creative work. So patents, basically, number one, are for some product or some process or some machine or some device. Second, copyrights would be for some literary, dramatic, musical, artistic work and such things. Trademarks are for, as everyone knows, this is the most commonly used form of IP protection, and a lot of common people are very much aware of this. So trademarks, you have brand names and logos and taglines. Industrial designs is a very not a very well-known type of intellectual property. It is the 2D or 3D design of any object. So a lot of times people get confused between patents and industrial designs. So let me give you a quick guideline as to how to understand what is the difference between the two. So looking at the example of a car, now design registration gives you protection over the aesthetic aspect of the car, how the car looks from outside, what is the color, what are the different cuts used, how do the headlights look, how are they shaped, and so on. Whereas patent protection is for the internal working or functioning of the product or the car. So this I think would help you understand a bit more about what, when to go for design registration and when to go for patent registration. Now let us look at patents in a little detail. Patentable subject matter. Now, the first image on the left is that of an electric light, very old, 1879 patent, the one on the top and the one below that. Then in the middle at the bottom, you have the TV remote control. At the top right corner, you have the typewriter. So these are the various examples of patents people have filed for and registered. So these are some examples that I'd like to share with you. Now, there are certain criteria for an invention to be called a patentable invention. we will discuss this in a little more detail. Now, by invention, it means that it should either be a product or a process. It should be a manifestation. An idea as such cannot be patented. It has to take the form of either a product or a process. So that is what an invention is. Novelty is your invention should be completely new with respect to all that there is available in the market. Okay, so that delta which you are offering as a value addition should not have been patented or even used in the market or in the field by any other person. That's novelty. Industrial application is the invention should be capable of being made or used in industry. It is not something that someone does at their house, because it should at the end of the day be capable of commercial exploitation. That's what this means. Now, inventive step is a little tricky. Inventive step means that the value addition or the delta which we just spoke of, that should not be arrived at by a combination of prior patents or prior, so not everyone patents. People have products which they don't patent, but which are commercialized in the market, which are widely available in the market. So while looking or understanding whether a patent is worthy of getting registration, this factor is checked, whether the value addition that is being offered by a particular innovator, whether looking at the technology available on that day as a whole, would any person having ordinary skill be able to deduce that value addition? If it is it an obvious extension, okay, of the currently available prior art? If it is a very obvious extension, then it may not be considered to be patentable. The last thing is subject matter. So there is a section in the Indian Patents Act known as, what inventions are not patentable. There is a huge list of criteria given there, which says that a certain invention cannot be given a patent if it fulfills this so and so requirement. So you, while advising or even the patent, so the patents office, when an application is filed at the office, it undertakes a huge scrutiny of the application, and on the basis of the points given here, there are a few other points as well, but these are the most important ones. So whenever a person is thinking of patenting, or whenever your client is thinking of patenting their invention, I would recommend that a basic background be given to him as to how detailed this evaluation is, from the end of the patents office. They look for quite a few criteria before deciding whether to give a patent or not. A majority of these things can be checked prior to filing applications by intellectual property professionals. Now, let us look at the patent registration process. Now, this process is highly complicated, but to save some time and to make the, to help you understand it very quickly, we have tried to represent it in a very simple format. So the first stage is filing the application. The second stage would be publication. The Patents Office publishes the patent applications, all of the patent applications periodically, after which the application is taken up for examination, wherein the points that we discussed in the previous slide come into picture. The scrutiny is carried out and a formal examination report is issued. You're supposed to respond to this examination report within a fixed time period, after which the fourth optional stage of hearing happens. So in the hearing, the patent applicant, the patent attorney, and the examiner sit together physically or over video conferencing these days. And whatever pending queries the examiner may have are discussed in detail. If the examiner is convinced, then you get registration. If not, then you get a rejection. This is the basic process. In this process, if any third party wishes to oppose a patent application, that also is, there are provisions given to facilitate that, but that's a nuance, so I haven't covered that here. Now, since I really appreciate the organizers in organizing today's talk, because intellectual property and registration of that has become very, very effective today, as of today. there has been a new provision introduced by the Patents Act known as fast track examination or expedited examination. Okay, so typically the patenting process used to take a long time, as given in the first row. It used to take 7 to 8 years for after filing to reach the last stage of decision. Okay, that is the standard examination process. Some people still prefer to go by that, and this option is always available. What I would like to talk more about today is the fast track process, which takes as less as we got a patent registration in 9 months, just a few days back. So that is excellent in especially for software patents. Technology is changing so fast, so innovators simply can't wait to hang around for 7-8 years, because it's very obvious their invention would not hold any value in the market until then. So this fast track process may take up to 3 years. Usually the time period is 2.5 years. Okay, so this is the duration for which this process lasts. Now, another thing that is very, very crucial that I would like to inform all of you as the first point of contact of most of the clients is that especially people from the academic backgrounds have a tendency to publish their research first before patenting. Okay, or even clients who are into businesses, they have a tendency of putting it on brochures, distributing it, putting it on websites, and putting their products out for exhibitions. So there is a very specific condition to patentability, wherein you have to file that patent application for an invention first before you put it in the public domain. Okay, there is a grace period offered, but it has a lot of caveats. So what is recommended is that once you and your client realize that this invention the client has come up with is credible, just think of patenting first and make the client realize that, just wait it out. Let us file an application first, and then you can commercialize it or exhibit it or whatever. If this does not happen, then your own, for example, this happens a lot of times. People come to us with research papers and tell us that we want to file a patent over this. And the research papers are 4-5 years old. Or then some clients have already disclosed or put up their products in some exhibitions, and then they come to us and say that this product is going really well in the market, so help me get a patent over it. So this does not work, because whatever in this effort of publicizing it, whatever material you put online, that can come and harm your case, because even if you are the person who has filed it, it will be considered prior art, okay, to your patent application. So there will be no novelty and inventive step that we discussed earlier. So this is very crucial to note that this is a common saying. This was a common saying, publish or perish, but that's not true. You should patent first. Now let us look at designs. Now these are the different variety, different examples of designs. Now, as discussed earlier, design registration is for protecting the outward appearance of any product. Okay, the functioning of the product may not be new. Okay, but what you or the client wants to protect is the looks or the aesthetics of a product. So for this design registration, we need to submit a few views, top, bottom, left, right, perspective view of the invention. And what this does is it helps clients stop competitors from making articles that look like this. So many a times it is very crucial for clients to protect the looks of articles. They have spent a lot of time and money on making sleeker designs. This is in the current scenario, how something looks is very important to consumers. So they spend a lot of time and money in creating a very aesthetic product. So this, and many a times when something is that aesthetic and is going well in the market, people feel the need to copy that as it is and sell counterfeit products. So here design registration comes most handy. So these are a few examples. Now, like we looked at the patentability criteria, there are certain criteria for design registration also. So firstly, the design should be new and original. It should not be published prior in India or any other country. So this requirement is similar to that of the patents. It should also not be publicly known in India or any other country. It should not be a technical or a useful function of a product. So by design, let us take the example of this glider here. By taking protection design registration for this, the applicant would not, or the proprietor of this design would not be able to stop competitors from making such gliders that work as this person's. Okay, the functionality or working is not something which is protected here, just how it looks. So the value addition that the applicant should bring in should be on the aesthetic level and not on the functionality level. Now, appeals to and is judged solely by the eye. Again, this explains that design registrations are for the outward or aesthetic appeal rather than the internal functioning. This is the process of design registration. Filing, examination, hearing, decision. So filing happens. Examination is quite similar to the patents, although it is not very in very much detail, because the patent scrutiny is very much detailed, and it is very much time consuming, because there are even 100-page patents which the examiners have to go through. So examining applications is quite easier naturally. So, but the process is similar. They issue an examination report to which you're supposed to respond in a fixed time period, after which there is a hearing. This hearing is also optional, and then there's a registration. Now, the process of this is also, it may take around 1 to 2 years to complete the whole process. There is no expedited process as given in patents as of now. Now, let us look at designs in a little more detail. Sorry, trademarks in a little more detail. All of you are aware what a trademark is. So this one would be a little quick, I guess. I'll be a little quick here. So how this is important. Okay, this is another slide where I would like you all to look at it in more detail, because clients would often talk to you about this, I suppose, and I do get a lot of colleagues who are CAs come with me with this query. So I thought it would be good if you are educated on this front as to what kind of a trademark should a client choose in the first place. Because what happens is, if it's not a good trademark, then the application is filed, it gets rejected, and it just wastes everyone's time, money. So it would be good to have a chat with the client on this. First is that this is from a business point of view. Your trademark should be easy to remember, speak, and spell. Okay. Second, this is important. Your trademark should, like your fingerprint, it should be unique or distinctive. Okay, because if it is similar to someone else's trademark, like we'll see in a lot of these disputes that we will be discussing today, then it creates competition problems. So your mark should be unique as much as possible. Now, the mark should be such that it is applicable across multiple verticals. So if there's a group who is dealing into food products as well as clothes, then you can't have a trademark XYZ Foods. So from that point of view, avoid marks which would deceive or cause confusion to the public. Right now, this again goes from the point of view of preventing your client from being the recipient of any legal notices or lawsuits. Because if your client's mark is confusingly similar, it may be done from a very honest intention, but if it is confusingly similar to other clients, some competitors' mark, then that competitor may come after your client with a legal notice or a suit. So it is good to always have a mark which is does not confusing. I'm being very careful and not using the word same here, okay, because that everyone knows. But even if clients have this tendency of using similar marks for some way, they feel comfortable with that, or I don't know, so this would be a good point to advise to your client. Next, avoid marks that are likely to hurt religious susceptibilities of people. Avoid using national emblems of India. So this is also prohibited. There are various acts enacted by the Indian government which say that you're not supposed to use the national emblems. So this also many a times inadvertently clients tend to, especially those exporting their products out of India, they feel the need to associate themselves with the country. So they do end up using the words India or the Indian flag or, the national emblem. So then the trademark would not get registered. So that was something. Now, also immoral, scandalous, and disparaging marks also naturally don't get registration. Now, ease of registration of trademarks. There are 5 different types of or types under which you can classify a trademark. First is generic. Second is descriptive. Third is suggestive, arbitrary, and fanciful. The ones given at the top or at the top end are the ones that may get registration comparatively easier as compared to ones at the bottom. Now, to give an example, generic mark is now Velcro is one such mark which is already synonymous with the product, or Xerox. The actual word is photocopy, whereas Xerox was the company who created the machine, but now everyone calls it Xerox, right? So those marks, these such types of marks cannot be given registration, or are, it's very difficult to seek registration over such marks. Descriptive marks is a very challenging. This is the most challenging. These types of applications are the most challenging to pass through, because the trademark registry is not very keen on granting registration to marks that describe a product. For example, let me give you an example of a mark building. The particular applicant is based or it deals in laboratory furniture. They set up laboratories for clients, different pharmaceutical companies or research laboratories and so on, universities. Now they decided to trademark the tagline building labs of the future. So this application underwent a huge, a very lengthy process of registration, at the end of which we unfortunately did not get registration, because the examiner was of the firm opinion that this is a very descriptive mark. The reason behind this is that, they prevent, you can't use words that are that your competitors may want to use in the future to describe their business, right? So, as simple as for this particular mark, there may be other people who would want to use that mark, because at the end of the day, it would also be building labs, right? And building labs of the future, it would be, then that way it would be unfair for them if they don't have that. Or, you can't, protect or try to seek registration for such descriptive words. Now, suggestive words may get protection because they don't directly point at what your goods or products or services do. They suggest it. So there's a certain level of guesswork or thinking required at the end of the from the end of the customer who's buying this product or service, to understand whether what this particular product is. So such trademarks are given registration. Arbitrary marks, there's no relation between what the trademark is and what the goods or services are. So these marks are very easy to get registration. Fanciful marks are marks which have been coined. The word has been coined by that applicant and therefore are very good candidates to get registration. This trademark registration process is quite similar to the patents. After filing, there's the examination. Subsequent to which, if there are some queries, they are discussed with the trademark officer, and then there's a decision. Now the point, the application is accepted. After acceptance, it is published for a period of 4 months. And if there is no opposition, it is granted registration. So there is a slight toggle in the sequence of the steps here. If you look at the patents and the trademarks, or if you compare both the things here, but overall the main or the crucial scrutiny points are similar. This process also from filing to registration may take around 8 months to 2 years. Now, subject matter worthy of copyright registration, types of copyrightable works. So literary, dramatic, musical, artistic, cinematographical films, sound recordings, dramatic works, all of those, photographs, sculptures, all of these things are capable of copyright registration. Source codes. So this is another thing where point of interest for all of you as practicing chartered accountants is that many a times clients working for software companies or clients that innovate in softwares, that is a separate a topic of discussion in detail, patenting or how to protect source code, how to protect object code, how to protect the intellectual property behind software. So many a times it happens that the computer related invention may not be patentable. So the advice that can be given to the client here is to go for copyright registration. which comes under literary work. Now, there is an important case law which will feature in our talk later, but it is not mandatory to seek copyright registration. The moment you create something on your own, like take a photograph or write an article, if you write your name at the bottom, put the copyright symbol and put the year in which you created that work, copyright will automatically vest in you. Okay, so this is for general information for everyone, for your own sake or even for your clients. So no law mandates that you should go to some government office and get registration, because copyright automatically vests from the moment you create it, provide you put it in some tangible format and write your identification and put the copyright symbol. However, it is, having said that, it is recommended that you should get your registration because of the following reasons. Mainly they revolve around, it helps you in the court of law. If there is any dispute, having a government certificate which says that so and so person is the owner of so and so rights, it becomes very easy to establish claim here. So that is something to be remembered here. For this is especially relevant for clients who foresee a dispute in the future. So if they already have something going on with some competitor, or if the work is that credible that there is a huge chance that competitors are going to pick it up and make copies of it and try to commercialize it, then it would be ideal to get registration. Now this process is also similar to the earlier processes. Once you file the application, you get a number, diary number. Then there's a period in which objections are received. There's the examination stage, hearing stage, and decision stage. Now, the term of a copyright, once someone gets copyright registration, the term for protection that is offered is huge. So it is for published literary, dramatic, musical, and artistic works. It lasts for 60 years from the beginning of the calendar year, next following the year in which the author passes away. Now, there are different types of works for anonymous or pseudonymous works, posthumous works, and so on. It's quite similar. There is a lot of legal lingo here, but essentially it would be useful to remember that once a copyright is registered, you get protection for almost 60 to 61 years for that. Now, in general, we let us compare the tenures of, we looked at the copyright registration tenure right now. So this is for patents, trademarks, and designs. So once a patent application gets registered, it is valid for a period of 20 years. Okay, so the 20 years start from the date of filing the patent application. After 20 years, this patent cannot be renewed and it goes into the public domain, meaning any competitor or any individual has then the legal ability to commercialize the once patented product after the expiry of these 20 years. For trademarks, a trademark registration is valid for 10 years from the date of filing. It can be renewed till eternity. This is very important. You can keep renewing a trademark every 10 years. So the life of a trademark is enormous, and it is a very, very useful form of protection that way. Now, designs, again, the term is 10 years from the date of filing, and you can renew it for 5 more years. Now, how to monetize your IP? So many a times, this is a common conception that people have, or misconception that people have, that, why should I seek for IP protection for something? The main thing that people think of is to stop competition. Okay, so that is IP rights in a sense definitely are negative rights, but they do have a huge and tremendous potential to make some money. So let us see how that is. Firstly, this is the point that we already discussed, monopoly rights. You stop competition. So at the end of the day, you are the only person selling that particular product out there. So, the commercials are quite clear. Second is right to license or franchise. Now, patent licensing is very much rampant. And, instead of just, holding monopoly with themselves, there are a lot of companies that license their products to competitors and get a share or a royalty from their sales. So this is a very, very much effective way to commercialize your IP. Second is right to, so licensing happens one way. Okay, franchisee is typically done for trademarks, where the trademark, the trademark holder allows a third party to use the trademark in return for some royalty. That's franchising. Right to cross licenses, let us come together, let us shake hands. You give us something, I will give you something in return. So if there are two competitors, especially this comes very handy for pharmaceutical companies, where they have one particular company, say, has developed an active ingredient for the treatment of COVID, and there is another company who has is selling drugs for treatment of fever. Now if the two companies, and both of them have patents over that, if both the companies join hands and make a formulation which has both of these things that are very much useful to a COVID affected person, then that's beautiful, because at the end of the day, they don't have to give anyone royalties and all. They just are allowing each other to use each other's technology. So this is absolutely crucial to keep in mind. The right to litigate. Now this approach is there is a slight doubt about the ethics of this approach, because there are certain companies which known as patent trolls. Many of you must be aware of this, that they just seek patent registration, don't commercialize it themselves, just go after other companies filing lawsuits demanding money from them, and in practice they don't really at the end of the day, the market or the common man is not getting benefited, because there is no product in the market. However, when this done in the right way, if you are a legitimate owner of a patent, and you are really commercializing it and the product is going good in the market, if there are people who are infringing upon your patent, you can always get injunction and get costs of this procedure. So that is another way to make money. Right to use as collateral. Now this would be relevant for you, because you can, as you must be definitely aware, that you can use, since intellectual property is an asset, even though it is intangible, you can borrow money from a financial institution by assigning your IP as a security for the loan. Okay, so this is another way in which you can use intellectual property attorney. So this would be my humble request to all of you, to talk to your clients about all of these variable approaches. It's just not this one thing that I would be able to stop my competition. There are other ways also in which you can use your IP very smartly. Now, let us begin at looking at the cases. Okay, we have shortlisted certain cases that we feel would be relevant to you. So here goes. So one thing to be remembered or noted is that intellectual property rights are territorial. So it is very important, or territorial or geography specific. So whatever is registered in India is registered in India. You won't have protection for that in the US. This is what that means. Let us look at a case law. Now, everyone knows the company Toyota. They filed a suit for infringement against the company Prius Auto Industries Limited. This is a 2017 case, and the judgment was, issued by the Supreme Court. Let us look at what happened in this case. This is the Prius car that is very popular abroad, that is manufactured by Toyota. What happened is, this company Prius Auto, which is a spare part supplier, company, they started making products that had these three brand names, Toyota, Innova, and Prius. Now Toyota filed this suit for infringement here. Now Toyota and Innova, both of these marks were registered in India, and both of these trademarks. So in trademark law, there are two concepts. First thing is whether the mark is registered or not. And the second thing is whether the mark is being used in commerce or not. So even if you don't, if there is registration, then you can file a suit for infringement of trademark. If there is no registration, but you have been using the mark for some time, then you can file a suit for passing off. Okay, so there are two different remedies available to people or business owners. One would be infringement suit and the other would be passing off suit. So in this case, Toyota and Innova, both these marks were registered, and they had also been, naturally they were used in India as well. So there was no conflict in the minds of the court as to where the merit in this case was, now this was a special situation where the mark Prius was not registered in India. So Toyota had no trademark registration for the mark, but the company Prius Auto had registered it in 2002. Okay. So again, the conflict was that since Toyota had no competition, but it was using the mark from 1997. So whose claim was the stronger? The question here, despite Prius Auto's registration of Prius as a trademark, could Toyota still claim that they have a stronger passing of claim to the mark, being prior users of the same? Now let us see what the court said here. The court reiterated here that IP rights are territorial and they are not global. Just because Prius was a well-known mark outside of India, it does not mean that it enjoys a reputation in India. So if you ask a common man, and this was when the suit was filed, it was a long time back. It was 2001. Okay, so there was no way that the internet also wasn't that much prevalent as it is today for people to quickly have access or know about things outside of their country as much as we do today. So that was also considered by the courts, and they said that it was contended by the court that Toyota may have registration outside of India, they may have a huge presence outside of India, but for the common Indian customers, the word the trademark simply doesn't exist. So from that point of view, the case of Toyota wasn't successful for the mark Prius. So they had to take into consideration Prius Auto's registration and concede or give them some royalty for using their mark. So what has to be established here, reputation outside of India does not matter. This especially is relevant for your international clients. Okay, that they may have, it may be popular outside of India, all that is well. But you, along with, stating that the mark is quite popular, you have to give evidence as well as to, of commercialization and popularity in India. Now, I am sure all of you, most of you have been faced with this issue, and your clients have discussed with you, especially business owner having in the manufacturing industry. This is a very common query or a common assignment that we get. This is a very common thing that companies, manufacturing companies, etc., employees after leaving these companies join their competitors. And then, since they have worked with this first company, they are aware of all the customers that they have. And, they help the other company in approaching the same customers, since they, so the customer lists are very crucial to a business. Okay, so recently there was a suit which we will discuss going forward, whether the copyrightability of this customer list, whether such customers lists are copyrightable or not, was evaluated. Now, this case happened at the Delhi High Court in 2018, Navigators versus Kashif Qureshi and others. Now, the suit was filed by an employer against former employees on the grounds that they had left employment with a confidential customer list and had began to compete in violation of the non-compete clause. So this employer alleged that this group of employees left the company with a customer list. They stole it in very common language, and then they shared this with the new employer, and they, that was unfair, or it breached the non-compete clause. So non-compete clause also, we'll be discussing it in detail subsequently. It is typically found in all legal agreements or employment agreements. So the question here is whether such customer lists can be considered copyrightable, and whether such employers can sue the employees for infringement, copyright infringement of such lists. Okay, so typically earlier, there was a doctrine that was used, which was known as the sweat of the brow doctrine. So what that means is there does not, for a work to be considered copyrightable, there is no skill or creativity required by the person who creates it. Mere hard work or mere putting together things, whatever diligence is required to do that, that's enough. So let us take the example of a telephone directory. So the telephone directory is just a compilation of numbers. There is no skill involved, and so on. A few, let's not say a few decades back, it was a common belief or a common legal precedent that such level of input or diligence was sufficient to consider a work copyrightable, meaning they found that the person who created the telephone directory could say that he had a copyright over it. Now, in 2008, there was a case which I will quickly walk you through. It was known as the EBC case, where the judiciary moved away from this doctrine and where they proposed that exercise of skill and judgment is necessary. So in this EBC case, there is a Supreme Court cases is a publication which a lot of all lawyers use, especially to go through the legal precedents. So the company EBC that publishes these, they were sued by someone saying that the works that you create are not copyrightable because it is out there in the public domain. What are you doing? How can you seek rights? So the person, the publisher, the editor in the legal proceeding said that it is just not a copy paste. There is a lot of skill, the person, while creating this particular publication, a lot of knowledge and skill is required. What to put, what should be the title, what excerpt should be taken, what should be avoided. So it is not a simple copy paste job like a telephone directory. Some level of skill and judgment is required. Therefore, it does deserve copyright registration. So from that case onwards in 2008, this particular standard is now used by the judiciary. So answering like this is the question that the case tackled, whether it is possible for employees to restrain former employees from using customer lists after leaving employment. So along with copyright, so it was held that, in this case, originality is a precondition that is proved by establishing a minimum degree of creativity, skill and judgment. So whether was it creative, what did it require any skill, did it require any judgment in making those customer lists? We will look at that in the non-compete and the confidentiality. Another reason was that these customer lists in this particular case were never published. So this, or published in legal sense, means written down anywhere. So all of this information, since these employees were working with this company for a long time, they had it in their heads. So they never copy pasted a file on their machine, or there was no file to be copy pasted from, because it was just common intelligence that you learn from your day-to-day work, right? So since it is a very crucial rule of copyrights that an idea cannot be copyrighted, or something in your head can't be copyrighted as long as it comes on paper or it comes in the form of a performance. There should be a manifestation of the idea, and the manifestation is worthy of copyright protection. So since there was no tangible manifestation, there was no copyright. This is what was said. Now, confidentiality. Another issue that was discussed here, whether these types of lists are confidential in themselves or not. So the court contended that since, these, for example, people in the business of manufacturing a very specific type of a fan that is used in computers. So, there are going to be a finite number of customers for such particular companies. So it's going to be, if all the information is, the list of customers is in public domain. So the court contended that there's no confidentiality as such in these, right? Because there are only so many customers who can be serviced. So it was held that this data wasn't confidential. Next, this non-compete clause, which says that, once an employee leaves some company, does he, typically employers have this clause put in agreements where they say that after leaving my company, don't join my competitor for 3 years, or, you are forbidden from starting your own business, which deals in the same things as I do. So it is a very common practice for employers to have such clauses, but there is a clause in Section 27 of the Contracts Act which prohibits this. Okay, agreement and restraint of trade are void. So in general, this can also be advised to your clients as to they have this concern that employees do have such clauses in the agreement, but they are very rarely enforceable. Okay, so in view of all these things, the court, let us see what the court held. Okay, so basically the court held that in this particular case, the employers, as is Navigator Logistics, didn't have a case because the customer lists that were of the contention here were not copyrightable subject matter. Now, this is a fairly interesting case. Inventions contrary to public order or morality. So in the patentability, eligibility for getting patents in the chart that we saw in one of the first slides, I mentioned about inventions being patentable and there being a section in the Indian Patents Act which prohibits some inventions from getting patent registration. So this relates to that. Inventions that are contrary to public order or morality can't be given patent registration. Let us look at an example. 7127 Delhi NP 2011. Philip Morris filed a patent application in 2011 for a device for delivering nicotine to a subject. Now, this is a cigarette, okay, the various components of that, and they have very smartly labeled it as a device for delivering nicotine to a subject. This patent was, there were a lot of other objections as well, novelty, inventive step related objections as well. However, one of the points mentioned by the examiner here behind a rejection of the patent was that it falls under section 3B, which is inventions which are contrary to public order or morality, or which cause serious prejudice to humans, animals, plant health or environment. So section 3B was used here. This was a very recent case in 2020 where this was rejected. So the applicant failed to explain how the nicotine delivery device prevents nicotine's addictive effect and how it does not pose a health risk. That is why this patent was rejected. Another example is 1098 Kolkata 2010, dissolvable betel quid and or tobacco composition. So here also, this was by ITC. This is a patent claim, a dissolvable strip comprising 60 to 95% of hydrophilic polymer, 0.2 to 4% of a binder, and 5 to 35% of at least one betel quid ingredient or tobacco. So this is a proper tobacco formulation to be used for by clients, which was also rejected by the same reason, as it is contrary to section 3B. Now, so this is something which I wanted to highlight here, that when your clients come to you for maybe discussing whether you think their invention should get a patent or not, whether they should file for a patent or not, if at all, then this would be something that you should keep in mind as to such inventions are not granted registration. Although there is a third party view to this approach by the judiciary as well. Some scholars or some practitioners believe that the patent office typically does not provide adequate reasoning as to why such inventions are rejected. Okay, especially once you consider this, that there are several restrictions concerning the sale, packaging and labeling of tobacco products. There are restrictions on the labeling and packaging, but its sale and consumption is not prohibited. So if that is the case, then why not give patents, is what one point of view is. Okay, so this is one thing to be considered. Other thing was, they have this particular study has also been carried out. There are a few rejections on morality basis, which include a sexual stimulation device on account of it being contrary to public order or morality, or a medicinal powder prepared from skeletal remains of corpses on account of it being against morality. So all of these are contentious issues, and some people or some practitioners believe that it is a form of a judicial overreach. It is not in the scope of the patents office too, but they are trying to bring in some more moral influence over how the society works. So there have been certain concerns with respect to this aspect too. However, it would be important to note that filing for such, at least the first two cases that we looked at, are fairly straightforward in my opinion in terms of getting a rejection from under section 3B. Now, this many people are not aware of. Okay, so if there is IP infringement, there is a criminal punishment involved as well. Okay, so let us look at that. So it's not just this comes under civil law and this is a corporate law matter, so there won't be any imprisonment or so. This is a misconception. So I would like to clarify that here today. Now, this case was very recent. It was with the Bombay High Court, Piyush Subhashbhai Ranipa versus State of Maharashtra. So what happened is, this person, Mr. Piyush, was manufacturing fake and substandard goods that were being transported and sold under the brand name of the complainant. So this Jain HDPE company is a very big company manufacturing pipes. So they filed a suit at the court saying what they found is this particular person was making pipes and was incorporating their logo on those pipes, as well as this person had forged the stamp of certificate of manufacturing license as well. So there, one of the informants of this Jain HDPE came to them that this particular truck is heading from one place to other currently with these counterfeit goods. So this complainant company sent certain representatives, they stopped the truck, they opened the boot, and they did find pipes being shipped from one place to other having trademarks of the complainant, Jain HDPE, along with this fake certificate. So immediately an FIR was filed because this, as we will, there are certain sections, section 63 of the Copyrights Act and section 103 of the Trademarks Act. This is a contention here. What happened is after filing the FIR, Mr. Subhash Ranipa was taken away by the police and he tried to apply for bail. So the question that the court was trying to solve here was whether the applicant is liable to get anticipatory bail or not. This is section 63 in the Copyrights Act, okay, offense for infringement of copyright or other rights. So this is, it details what infringement offenses would be. Look here, line number 2, shall be punishable with imprisonment for a term which shall not be 6 months, but which may extend to 3 years. Okay, imprisonment has been mentioned here. In the section 103 Trademarks Act talks about trademark infringement. All the possible ways in which anyone can infringe anyone else's trademark have been given here. And at the bottom, you will see be punishable with imprisonment for a term which shall not be less than, it's quite similar, 6 months to 3 years. So it is not that since this is a corporate case or a corporate dispute, there is no criminal remedy. There definitely is a criminal remedy, and of course there, in this case, there have been several judgments also. So relying on those judgments by various courts, the Bombay High Court held that these offenses are not bailable. So it, in my opinion, it would always be good to advise clients this as well, as so they have to be very careful about because at the end of the day, it is while running a business, nothing is black and white, and everything can't be 100% risk free. Businesses have to take risks, but having said that, it is very important for us as professionals to advise them of the consequences as well in this case. So it has a criminal punishment associated with it, and it was also very recently held that it's non-bailable. Now, again, as we talked about the contrary to morality approach, this approach is also, or this judgment is also being criticized because of the following reasons. Such heavy punishments dissuade creativity by leading to artists self-censoring their works. So this is a very common concern that clients have, that we have to talk to them or consult them with, is that then they are very scared also to start businesses or then create intellectual property. So it has to be a balance, especially trademarks also, because there are a lot of opposition cases coming up these days. So how can one start a business if the atmosphere is so adverse? That is a very common question. But so let us hope that there is some middle ground reached, and some further judgments come into picture soon, so that there is a not a very dire consequence as the one given here. Now, compulsory licensing of COVID-19 treatment drugs. Now, there is a provision in the Indian. So typically, what do patent rights do? Patent rights help you to stop competition, to be put in simple words. Now, what happens is big companies, big pharmaceutical companies, once they have patents, then they don't allow generic manufacturing companies to sell those, right? Okay, manufacture those companies. Now, there is a provision. What happens in this case is many companies, especially in the Indian context, many companies based out of US or Europe, they take patents in India, but they don't manufacture in India. Or if they do manufacture, then they sell it at very, very high prices, which the Indian population can't afford. So there has been a provision in the Indian Patents Act known as a compulsory licensing, where such non-performing companies, or if they are, firstly, if they are not commercializing in India, or if they are selling it at a very high price, then there is a provision which is legally mandated. If a small company approaches them for permission to make those, make their patented product, in turn for some royalty, then they are, it is made compulsory for them to give them such license, for manufacturing those drugs. So there is this is the context. So in the recent pandemic situation, let us see how that was relevant. This is the section that I am talking about. This is section 92 in the Patents Act 1970. Special provision for compulsory licenses on notification by central government. So, there is we can, this is also like software patents. This is a separate topic which undergoes detail, or which requires or mandates a very detailed talk. But look at this here, line number 2, national emergency or in circumstances of extreme urgency, or in case of public non-commercial use. So on a higher level, if these three situations are relevant in a particular case, then it is necessary that compulsory licenses should be granted at any time after patent registration by notification upon. Okay, so let us look at this case. Eli Lilly and Company, they have a patent 2070765. Eli Lilly is the authorized licensee for baricitinib, which has been used in combination with remdesivir to treat COVID-19 patients. Now, both of these drugs, as you all know, remdesivir everyone knows now. So along with it, this drug baricitinib also has been used widely for the treatment of COVID-19. So, and this only Eli Lilly had the legal rights to manufacture and sell it in India, to actually sell it in India. So, and in this case, Natco Pharma is an Indian pharmaceutical company that approached the controller of patents to request compulsory licensing for manufacturing this baricitinib. Now, Eli Lilly being very much considerate in this case, they gave a royalty-free, non-exclusive voluntary licensing pact. They gave that license to Natco and 5 other Indian drug manufacturers for manufacturing and commercializing baricitinib. As Eli Lilly did this on their own, then Natco pharma company, they took back their case with respect to this particular drug, baricitinib. So this is important that, this was what happened during that time, during the last couple of years. Now, Bajaj Healthcare is another company that approached Eli Lilly to get compulsory license. However, Eli Lilly has not given registration to BHL. So BHL has directly approached the patents office to get registration. Now, this is crucial to note that BHL, the price claimed, okay, by Eli Lilly is not affordable to the public. Now, just look at this. For 1 mg, 2 mg and 4 mg tablets, the price is 14 rupees, 18 rupees and 28 rupees. This is what has been claimed by BHL, that if we are given a license, we'll sell it at these, this much, as opposed to Eli Lilly's drug, the entire course of which costs about 45,000. So there's a huge difference. So this is to give you some context as to why such compulsory licenses are given and what is the requirement and thought process that goes into this. So this is about compulsory licensing. Now, since we are talking about emergencies and urgencies, some people do like to take advantage of that in a very unfair way. Let us look at how that happens. Now, on the left, you see Cipla companies. These inhalers, I'm sure everyone is aware of, Pudicort inhaler or some other inhalers. They have level inhalers. They are known as respules. We as common man, we don't really read everything, all these terminologies here and there. We are just concerned with the main drug or the name of the actual name, like Prosin. We know that, but we don't know the drugs. But in this case, Cipla had trademark respules. They had trademarked the word respules. Now, Sun Pharma, which is another big Indian company, they used the word respules and started selling their own pharmaceutical formulations. So let us look at what happened next. So Sun Pharmaceuticals allegedly infringed Cipla's copyright and registered trademark. Cipla had filed for a permanent injunction against Sun Pharmaceuticals for selling deceptively similar goods. So they clearly had the mark which was registered by Cipla on their packaging. Now, an interim injunction was granted in this matter, okay, to Cipla. In response to that, Sun Pharmaceutical, now look at this audacity. Sun Pharmaceutical contended that the company had stocked up a large amount of goods under consideration. And since these were medical supplies which had an expiration period of 1 year, they were prayed to be excused from litigation and to be made available for commercial supply. So the court was very honest here, and the court was very hard here that the argument of urgency and public interest was not held to bear any weight in the question of trademark infringement. Even if you have a go down full of medicines, and even if the medicines are really required by public out there, you can't just infringe anyone else's trademark. That was what was held in this particular case. So you can't just say that, it's urgent. It's not, especially in the trademarks context, it does not form a very promising ground. Now, this is again, we talked about copyright registration in detail earlier. So is it really mandatory? Let us look at that. Let us look at what the case laws say. Now, this is also a very recent case, March 2021, Sanjay Soya Private Limited versus Narayani Trading Company. Now, the one on the left is the plaintiff's trademark. Okay, the one on the right is the defendant's trademark. Look at how similar the two marks are. Okay, so this plaintiff, there is a way in which you can seek trademark protection not only for words but also for the outward packaging. Okay, how it looks, that those are known as label marks. So this company had, Sanjay Soya had protection for the entire part of this particular packaging, and this competitor has come up with this. Now let us look at what happened. The plaintiff, Sanjay Soya, instituted a suit for infringement of trademark and copyright in respect of its label mark against the use of similar mark. The plaintiff's label, now this mark here, Soya drop, was registered in class 29 and has also been used. So registration is also there and use is also there. The defendant contended that since the plaintiff had no registration on the plaintiff's label under Copyright Act, no release under the same could be claimed. So people tend to give a lot of different grounds which may not stand in the court of law. This is one of those wherein they say that, they may have trademark registration, but they don't have copyright registration. In this case, the Bombay High Court ruled that registration of copyright is not mandatory for obtaining relief in an infringement action. Now, there was a 9 years ago, there was a case that was, there were quite a few judgments actually at that point where the court held that if there is no trademark, if there is no copyright registration, then you cannot be successful in an infringement suit. For in this case, if this had happened 8-9 years ago, then the court would have said that since they don't have copyright registration, they won't get relief in this case. Okay, but the blunder was corrected by the Bombay High Court and said that, let us look at this. This is the Indian Copyright Office website, what it says. Is it necessary to register a work to claim copyright? No, acquisition of copyright is automatic and it does not require any formality. Copyright comes into existence as soon as work is created and no formality is required to so on. However, certificate of registration of copyright and entries made therein serve as a prima facie evidence in the court of law with reference to dispute relating to ownership of copyright. So this is the contentious issue. This line here still indicates that in order to be successful in a suit, it is recommended that you have a judgment. But the recent case that we looked at here, the court ruled that registration is not at all mandatory. This is also important to have in mind. This is a screenshot of the World Intellectual Property Organization website. That is like the governing body of all the countries, okay, IP, relating to IP, intellectual property. So what they say is that copyright protection is obtained without any formal procedure. A work is automatically protected as soon as it exists without any special registration, deposit, payment, or any other formal requirement. So this is also a welcome change and a good thing because people don't have to go through the process every time. Now, research and development. Is it an exception to patent infringement? Earlier, a lot of companies have given this excuse and they have not been successful. But let us look at a recent case law here. Now, this is a July 2021 Delhi High Court judgment between Merck and SMS Pharmaceuticals. Now, this is Januvia tablets for sitagliptin. It is used for the treatment of type 2 diabetes. Okay, it is manufactured by Merck. And so what happened is Merck had alleged that SMS Pharmaceuticals had infringed its patent in sitagliptin and obtained an ex parte interim injunction. So SMS Pharmaceuticals, I tried to find a conflicting image, but it's not actually easily available on the internet. But what they did is the defendant here infringed on the sitagliptin patent of Merck. So SMS Pharmaceutical, what SMS Pharmaceuticals said is, so what was actually happening is SMS Pharmaceuticals was exporting this drug to undertake research and development purposes for themselves. So the Delhi High Court, what they said is, on the condition that it files an affidavit mentioning the quantities. So basically the Delhi High Court allowed SMS Pharmaceuticals to undertake such export because it was done for research and development purposes. Let us understand why. There is a section in the Indian Patents Act which says that certain acts not to be considered as infringement. If you are making, using, selling, importing, or even exporting a patented product, then, and if you're doing that in relation to the development and submission of information required under law for the time being enforced. So what this says is, this is known as the Bowler exemption, wherein if, let me take you back here. Right. So Merck company is manufacturing sitagliptin, SMS, and it is selling it all over the world. It has presence in India. It is exporting it out of India because it is a patent team. It has the right to do so. Now, SMS Pharmaceuticals also started exporting it out of India to its international labs to, for the purposes of R&D. So naturally, Merck and got into a lawsuit with SMS Pharmaceuticals and they wanted to stop this export. So what SMS Pharmaceuticals said is, you can't stop this, you can't stop us because we are engaging in research and development. So the Delhi High Court allowed this because what SMS was doing actually, it was undergoing research and development, was studying this particular formulation so that after the expiry of 20 years, it could right away start manufacturing this tablet and without the public suffering, because international companies, and what this was about to do is it was developing its generic version, right? So many times foreign or international companies charge a very high cost for tablets. So generic, that's why generic companies are the tablets or pharmaceutical products manufactured are very much cost effective. So from the public health point of view, this is very relevant, and this is known as the Bowler exception. Now, this particular case has some reference to the US laws. Let us look at the US laws here for a bit. This exemption from infringement is known as the Bowler exemption. Okay, it is an exception or exemption from infringement of the patentee's right for certain acts relating to manufacture or use of the patented invention for the development and submission of information to a regulatory agency, which is the FDA or the Drug Controller General of India. So whenever a generic company has to manufacture a pharmaceutical formulation, it has to undergo a lot of trials and it has to submit a lot of data to the drug controller. So this is what they have, and for this purpose they need to test the actual patented product and compare it with theirs, with the generic companies. So this is what falls under the ambit of development and submission of information to a regulatory agency. This is allowed. So this is a very, very much landmark case that happened in the United States in 1984. Okay, Roche Products versus Bowler Pharmaceuticals. The court held that the competitor Bowler's intended use of Roche's patented product, okay, to derive FDA required test data for approval of its generic drug would be infringement. So in this case, the court held that since Bowler was a generic company manufacturing a product, using the patented product in some way, it was causing infringement. The highest court, which is the Court of Appeals, it reversed this decision and said that this is allowed. That's why this is known as the Bolar exemption, and therefore it became like a globally acceptable thing to do. Okay, development of generic or non-patented medicines, or use of patented medicines by other companies to develop spin-offs which would be commercialized after the expiry of the original patentee's term. So because of this case, overall globally patent laws were amended, and there was a section that was included especially in the Indian Act as well. So in this case, since SMS Pharmaceuticals gave the defense that it was using this particular patented product for R&D, it was not held to be infringement. Now, fair use and copyright infringement. This is a very interesting case. So there is this YouTube channel, News Laundry. Okay, what they do is that they essentially, in common language, they troll big newspaper outlets like Aaj Tak or India Today for the news that they publish. Okay, and in doing so, what they do is that they show some certain clips of these companies or of these agencies, and then they give some critique over it as to if they what they don't agree with that, what were the problems in the reporting, and so on. So as a completely politically motivated effort, Aaj Tak and India Today approached YouTube and brought this channel down. So let us look at actually what happened in October 2021. News Laundry received multiple legal notices from Aaj Tak and India Today. What Aaj Tak and India Today said is that you can't be using our clips in your videos, and since you're doing that, you are infringing our copyright. So Aaj Tak and India Today approached YouTube, and they said that this particular channel is an infringer. So, there is a separate process that YouTube follows, which I have included here for general information. I thought it would be useful to or interesting for you to know that. But since they received such complaints from Aaj Tak and India Today, this channel was shut, okay, for some period of time until the dispute was sorted. So these are the political implications, and how entities can use the loopholes and can use or enforce IP rights in a negative way. Just a minute. I'm sorry. Yeah, News Laundry on its YouTube channel used certain clips of Aaj Tak. This we already discussed. Now, this is what YouTube says. Okay, they first agree that the first rule of copyright is that you should be an independent creator, or you should make sure that you didn't make or use content of someone else's video. Okay, such as music tracks or snippets of copy. This is what they agree to in the beginning. This has been taken from the YouTube website. Okay, we looked at the overview. Now, fair use is use of someone else's copyright work for fair purposes. Okay, that is allowed. Or what are the exemptions? Now, fair use in the US law allows reuse of copyright protected material under certain circumstances, which are commentary, criticism, research, teaching, or news. The disclaimer that I used today before starting this session, of teaching or commentary or, such things, which are considered fair because you are not using it to commercialize or gain commercial benefit. You're not using it to pass yourselves off as the actual IP owner. Okay, it is just for another purpose, non-commercial purpose, which is allowed. So here YouTube is allowing, and it is being very clear about what fair use is. They also have a policy about, if a content creator on YouTube feels or observes that, their content has been used by someone else, what can they do? How can right holders make copyright claims? Then there are various approaches given by YouTube. There's a web form where you can actually submit a written complaint. Then there are 2 softwares that YouTube uses where, content creators themselves can upload their videos, can upload or share the link of a contentious video where they feel there is an infringement, and YouTube uses artificial intelligence to compare the 2 videos as is given here and actually give an opinion as to whether there is infringement or not. Okay, and then this is important now. Just look at this. If a copyright owner submits a DMCA complaint through our web form, we take down that video and apply a copyright strike. If a user gets 3 copyright strike in 90 days, their account along with any social channels will be terminated. We also have tools to help creators. So if someone if you are the recipient of such strikes, then you can resolve it by, firstly allowing it to expire, not doing anything about it, or requesting a retraction, ask the complainant to take back their complaint, or you submit a counter statement. Okay, so and then this is handled by YouTube offline on its own. So, this particular India Today, Ashtak, they sent 50 to 60 legal notices to News Laundry, and without, approaching them first, they directly went to YouTube first. So that was another contention that News Laundry had from their point of view. Now, this is an excerpt taken from the Copyrights Act, Section 52. It says that certain acts not to be considered as infringement of copyright. Now, look at this. What is a fair dealing? A fair dealing with any work for the purposes of, so if you're watching something, someone else's copyright at your own house for your own personal use or research, that's allowed. For criticism or review, it is very clearly given here that, if you're using it for criticism or review, then it's allowable. So in the present case, YouTube's copyright takedown mechanisms were used as a legal mechanism to take down criticism. What Aaj Tak and India Today were doing is just, they wanted to stop getting bad reviews, stop the public from looking at bad reviews of their news. So and they based that on Section 52, which we just looked at. And so the copyright exempts certain acts under the heading of fair dealing, for if you're doing it for criticism or review. Now, so this is currently an ongoing case, but I thought it was relevant. Another thing is that, such kind of enforcements are very bad in terms of free speech. And in general, the ethics point of view, it is using the bad side of the law to get what you want. So that is another point to be talked about. Now, we are at the last case. This I thought is very relevant in terms of what happens is getting right strategic advice as to what to protect, why to protect, what is also very much important. So let us look at what happened here. Everyone is now, this is a very, very recent case, Jan 2022, between Hamdard and Sadar Laboratories. So this is Hamdard's Rue Afza. I guess everyone is aware of this. Now, there is a competitor company that started manufacturing and selling Dil Afza. Now, naturally, Hamdard filed a suit in the court in this matter. The Delhi High Court refused to grant an interim injunction in favor of Hamdard in case of trademark infringement. Let us see why. Hamdard alleged that Sadar's Labs had infringed its well-known trademark in Rue Afza and was passing off its products as those of the plaintiffs. So what they were saying is they tried to make the packaging look very much similar to ours, and they use similar words. So they are trying to make customers believe that this bottle is actually ours, and they would therefore pick it up, right? So and the major argument that Hamdard had in this case was that the words Rue and Dil, the meaning of both words is the same. So what Hamdard was saying is that they were trying to actually seek monopoly over the meaning of something. So Hamdard claimed to have been using the mark for more than 100 years, and they have trademark registration for this since 1942. And they claim that in March 22, Sadar Labs launched a Sharbat Dil Afza with mark, getup, and design deceptively similar to theirs. Look at what Sadar says. Sadar Labs argued to have filed for registration. They argued to have trademark registration for Dil Afza in 2018, and they claim to have used since 1949. They argued that Hamdard did not hold separate, now this is very crucial, did not hold separate registrations for Rue and Afza, thus could not claim monopoly over the marks Afza, and that Afza was not a distinctive word. The judgment notes that both Rue Afza and Dil Afza are registered marks, and thus the exclusive right to use could not be enforced against each other. This is very, very crucial advice or judgment. The judgment holds that the marks of the plaintiff and defendant are not identical, even if the meanings are the same. Seeking an injunction because the meaning of the word is similar and not the words themselves did not work in favor of. So what the court intended, if Sadar had used Ruha Afza or something like that, then that would be considered similar, or Aru Afza, something like that. This word is totally different. Even if the first words mean something similar, the words themselves are different. And to top it, Hamdard does not have trademark protection for this suffix. Now, Hamdard's contention is that Afza, we are the only manufacturers of, only our brand. This word is very distinctive to us. But what was held by the court is you don't have registration for it. So that is very important in terms of how you plan your strategy. You know, it's not that you, okay, so this is my trademark. I have trademarked the whole thing. Now I'm safe. That's not the case. You have to very intelligently file, you know, multiple applications, especially if you're a big company, so that you are not faced with such a problem going forward. Another case I'd like to highlight here is between Bharat Pay and Phone Pay. Okay, so both the trademarks, you know, when Phone Pay came, Bharat Pay filed a trademark infringement suit against them with the same purpose. Bharat Pay made the same mistake. They hadn't registered capital PE as their, you know, they had registered Bharat Pay as such together as one trademark, but they hadn't registered the word PE or the as one of their trademarks. So they had a very difficult time trying to convince the court, and it was held not to be infringing. Pool Pay or this thing was not held to be infringing of Bharat Pay. Yes, so I think I am done here. If there are any questions, I would be happy to talk to all of you. Mr. Harshavardhan.
A very informative session. I'm sure the members have benefited a lot, especially with the practical case studies and those that the brands that we see day to day. So I think the forum is open for members in case of any question answers. Anybody who may have a question? Yeah. Can ignorance / unawareness towards existing copyright be defense against infringement case?
Well, no, actually, this is a very common principle of law that ignorance of law can never be used as defense. You can't get out of any situation by saying it's not, you are not aware, because law makes it mandatory for you to be a very aware citizen or a businessman. So you can't say that I wasn't aware. There is something known as honest concurrent use, especially in the context of trademarks, but that is a separate issue. Trademark registration, you know, two people can have the same trademark in rare cases.
Okay. Members, if you have any question, if you can raise a hand, you can put it in the chat box. Okay. So it was a very interesting session, actually. What is the costing of each? Okay. Costing as in the charges from the IP office or what? I mean, Charmiji?
So basically, there are two aspects to it. One aspect is the government fees, and one aspect is the professional fees. Right. So one aspect is the statutory, and one aspect is so government fees are basically for individuals, MSMEs, or startups. The fees are subsidized, and for big corporations, naturally the fees are slightly higher. And depending on which type of service you want to take from the lawyer or your agent, the fees differ. So usually there's a schedule of fees, so it will be difficult to quote an amount to you right now.
Can you brief about the penalty for ignorance?
Well, it's the same. We already talked about other different trademark, and there is no penalty for ignorance as such. What would happen is you would be an infringer. So whatever penalty an infringer would get, you would also get. But it depends on a lot of things. So it's very difficult to pinpoint that. That would be the judge's duty. There is nothing as such prescribed here.
What is the procedure to become a registered IPR agent?
Okay, so that is an interesting question. Actually, we talked about 4 different types of intellectual property. Now, patents and designs, in order to practice in these 2 domains, you need to have a technical background. You need to have a bachelor's, at least in maybe engineering or medicine or sciences, basic sciences, botany. Some form of the one of these sciences is important, because the logic is that you should be able to understand people's inventions if you have a science background. So in order to practice in patents and designs, you need to have technical background. For trademarks and copyrights, being an advocate should work for you. There is another exam known as a trademark agent exam, which you can appear for. And then, I mean, that could be a lucrative option for CAs, but this has to be looked at in a little detail. This exam is not very, it is not carried out very frequently. So you will have to take it up with the registry one-on-one and see when the exam is happening next and so on.
Right. Members, any other questions, or can we conclude the session? Okay, in case we get any questions afterwards, we'll just send it to Rujuta ma'am, so
Sure.
that you can in touch with them directly. I now request our Thane branch Vice Chairman, CA Rajnish Sharma ji, to present a formal vote of thanks.
Good morning, Harsha. Thank you so much. First of all, Rujuta madam, thank you so much for accepting my invitation and presenting this wonderful, informative webinar. And I also thank all the participants over here to attend this session, yesterday's session as well as today's session. Hope both the sessions were excellent ones to start with this subject, and we would certainly take up more webinars on this, seminars and webinars on this subject, so that we could explore an area of practice as well. A thank you to the managing committee of Ratnagiri branch as well as Thane branch, and to the Thane branch staff.
Rajnish bhai, you're not audible. All right, I think he's facing some connection issues. Well, anyways, let me conclude what he started. Thank you so much, Rujuta ma'am, for accepting this invitation. And specifically, I would like to inform the participants that she actually had some travel plans today, which because of when we were talking about requesting her to take this session, she was kind enough to reschedule her travel plans. So thank you so much. That shows an exemplary commitment to the profession. So thank you so much for taking this session, and thank you for all the attendees for making this a success. And we hope to see you in other sessions as well. Thank you so much.
Thank you.